Deputy Daly.
Thanks, Ceann Comhairle. Obviously, your amendments 4 and 10, Minister, are trying to roll back on the amendments that Deputy Wallace succeeded in getting past a committee. And our Amendment 5 here is really just a companion amendment to the ones that we did succeed in getting put through a committee, and is necessary if these two amendments remain in the bill, which I believe that they absolutely should be. I suppose the key points here for us, well, you know, the bill has undoubtedly improved a good bit from what it was originally, thanks in a large part to the work of Senator Alice Mary Higgins. But one of the biggest problems with it is these bits here, which is that it's fatally undermining the issue of voluntary consent, and is enshrining, if you like, coerced consent in a certain way, and that's why we will be sticking to our guns on these. I suppose there's a couple of things. I find it really unbelievable that we have to argue this point at all. To be honest, it's so really clearly wrong that the state would hold someone's social welfare payments hostage until the person surrenders and gives up the right to privacy, which is actually one of the fundamental rights under the ECHR. But that is how the PSC card has been used by the Department of Social Protection to date. What we're saying here is, if somebody wants to use the PSC to verify their identity, or if they want to give a body access to their public services identity, that's absolutely fine. We've no problem with that, and nothing that we're putting forward here impedes that. All we're saying is, if they don't want to do that, then they shouldn't have to do that. They should be able to produce, for example, a passport. When this issue has been raised before, and I don't know if the Minister has changed his tune on this and whether there's a difference now, because when it was raised previously, we've been told that there will be always alternative ways to verify your identity will be offered. You've said that previously. And if that was the case and you're still sticking to that, well then what's the harm in having our amendment in place? It's not going to undermine that at all. So I don't really sure where you're coming from in terms of that bit. And if it is, you know, if it isn't provided for an alternative mechanism, well, we think that it absolutely should be. We're not prescribing what the individual service provider should use. We actually don't care what they say the requirement should be, but we're just saying it can't be the only provision. And I think, leaving aside some of the amendments that were some of the discussions at committee, there is a serious point here. I mean, it's one thing to submit a photograph or a document with your address on it. It's quite another thing to be required to provide facial image biometric scan. And if we hear it again, I really hope you don't say it, that the PSC database doesn't store biometric database, we'll be, I don't know what, well, we're pretty sick listening to that, because the intrusiveness of the data requirements of the PSC means that the PSC is in breach of the requirement under EU and ECHR law that state interferences with privacy must be both necessary and proportionate. And the PSC is not necessary because alternative forms of identification, including passports, are available and were previously sufficient for the purposes of accessing public services. So the idea of systems breakdown going into overload applying here doesn't apply. Most people probably won't have a problem with offering the information, and that's fine. That's great if they do. It's for the people who don't want their data shared across a body of potentially 150 organisations and so on. And in that sense, the PSC is disproportionate because it requires people to link all of their personally identifiable information into one database shared by numerous agencies, and that interferes with privacy rights in a manner that far exceeds the stated goal of easy and convenient service access. So putting all this information, actually private information, even into a hackable database, to be honest with you, goes even further than that, and I actually frankly think it's absolute lunacy. And I think the key phrase really is state interference with privacy. Because you see, if the state asks somebody, you know, do you want to give us X, Y, Z parts of information about yourself, and in return we'll give you this handy little card now that you can use for all of your public service, a lot of people would say yes. And if the state asks, well then interference with privacy doesn't apply in that situation. When it becomes interference with privacy is when the state puts a gun to somebody's head and basically says, give me all your data or we're going to cut your services off. And I find it very difficult. I don't know why the government can't really get that point. And I think by interfering with privacy in a way that's neither necessary nor proportionate, I can guarantee you now, and I'm happy to put it on the record, the state is setting itself up for all sorts of problems, not just with the ECHR, but also with the GDPR. Without question, fines will be levied if the government succeeds in having our amendments removed. So I really hope they aren't, and that amendment number 5 is kept to go in tandem with it.